Welcome to Thursday. It's a Justice Thursday conversation, and we have a judge joining us in the Situation Room. The Honorable Justice Ocharo Kebira is the judge of the Employment and Labor Relations Court. He's our guest today. Good morning, Judge.
Good morning.
Welcome to Kenya's biggest conversation.
Thank you for having me.
That's the hot seat of the Situation Room.
Sure.
The last judge we had in this Situation Room was just 2 weeks ago, and it was also a judge of the Employment and Labor Relations Court. And we were looking forward to the symposium that we've been holding this week at the KICC. 10 years of the Employment and Labor Relations Court as a superior court.
Sure.
Hey, Your Lordship. Munasikia vizuri sana.
Yeah. It's been a milestone.
Yes. To welcome you to the conversation, CT has the day's proverb.
Yes, our proverbs for the whole of this week come from the country of Guinea. Guinea-Conakry, as it's sometimes referred to. We are quick to say it is not Guinea-Bissau, neither is it
Equatorial Guinea.
Neither is it
Papua New Guinea.
Precisely. Yes, this
Neither is it Guinea-Fowl.
This is the Republic of Guinea. Yes. Now, a proverb for the day: he who builds his own throne rules over a desert.
He who builds his own throne rules over a desert.
Yes.
My lord, this proverb from Guinea, what's your interpretation of it?
My God, I understand you teach proverbs here.
Now that is not only new, it's rich.
Kabisa.
We teach proverbs.
Okay, this I get it. When we talk of creating a throne, I'm looking at the bearer of the throne, the king. So you cannot be a king minus people around you and supporting your activities, supporting your leadership. Otherwise, if you don't have that, then the throne crumbles.
And what's the significance of them saying, he who builds his own throne?
Yeah, you can't do it alone. It has to be through support of people. It has to be people-driven. Yes, that's how I look at it.
True.
Yeah.
Because even if you look at monarchies, yes, there are people who declared themselves king. There are those who deposed others. But you, as his lordship says, you had to have support. You couldn't do it on your own. You may have led. You may even feel that your rulership was ordained by the Almighty God, but there's a support system which has to be given to you by people. Otherwise, this whole process crumbles. It doesn't make sense. Yes.
Indeed. Judge, how long have you been at the Employment and Labor Relations Court?
In that group that was nominated in 2019, but unfortunately sworn in 2.5 years in 2021. So I'm very, can we say 1.5 years? Yes.
But that's 1.5 years of serious and intense work. Yes. But before that, having been an advocate, having been somebody who's practiced law and an officer of the court, you knew the challenges that this court has been going through, even from the elevation of just it being a department in the labor ministry now to becoming a superior court. It's a big milestone. When you applied to join this court, why did you do it?
First, I must say that, in life, you reach a situation where you say you want to serve society in this forum, not the other forum. I had been in practice for like 21 years. So I thought I had amassed enough experience, and, my spirit was telling me you're better off serving in judiciary so that, Kenyans are served. And besides doing degree in law, I have a master's in human resource management, and maybe that was one of the factors also that attracted me to this court, because human resource and employment and labor law are like twins conjoined at the hip.
That's indeed true.
Yeah.
When you joined, you found a number of judges who were working really day and night, resolving the disputes that have been brought before them for adjudication. And how has it been for you since you joined in 2021?
Yeah, it's been busy, it's been hectic, and considering we came in this court, a court with lots of cases pending, huge backlogs. In a sense, it was understaffed, having like on 9 judges, delivering justice throughout the nation. That was a big and heavy burden on them. It ends the backlog that we got. Yes, but I can't say so far so good. We are doing well. We are trying to reduce backlog. Yeah, and you realize like the year 2021, 2022, yeah, our clearance rate was high at 161%, and we were rated the best. Yeah.
So you're marking 10 years of the Employment and Labor Relations Court. There's been a symposium going on at the KICC, and we've been announcing it this week. It's also being broadcasting on TV and live streaming. What exactly has been happening at KICC?
Yep. In a nutshell, we were interacting with the consumers of justice in the area of employment and reparations, trying to get their feedback, legitimate feedback on what we are doing best, what we are not doing good. We were also trying to, promote awareness as regards that all this court plays, because most people think that our court is a court of employees, not employers. A serious misconception. Again, this area of employment and reparations is an area which keeps on evolving day in, day out. So, sharing best experiences and practices, comparing, and sharing jurisprudence emerging in the several areas that are just coming up. Yeah.
The issues to do with labor relations, if I simply reflect on my experience, it often has more to do with how human beings respond to situations than matters to do with labor. I'm going to explain what I mean. Someone enters employment and they usually sign a contract, or there's some document they sign to sort of like ratify the terms and conditions of the work they do. Then a disagreement arises, and the point of discussion will be that document that was signed. But in signing a document, in my mind, what we seem to be declaring is a state or a situation of mutual mistrust, because if we speak and agree and we undertake that what we agree on is true, then why do we need to write it? Why do we need something, or why do we have to make it a document when our laws also recognize that you can agree verbally and it can be binding? So I'm saying it has to do with human relationships. It has to do with how we human beings respond to things and the unlikely interpretation and understanding of our nature. Meaning, you can think a human being will conduct themselves in this way, and yet they will do something that you completely hadn't anticipated. So it's like you need a structure within which you can actually now adjudicate this. Now, to my question. In the time that you've been in the Labor Relations Court, what would you say is the preeminent, or what are the preeminent issues that are brought before you? What are the things you see more often than others?
Okay, I think predominantly issues of unfair termination. Unfair termination in a sense that, as you say, people tend not to, stick to the terms and conditions set forth in the contracts of employment. People tend not to follow the laid down statutory procedures for conducting themselves within the working environment. Yeah, and at the end of the day, we get cases of unfair termination. Yeah, and those form the bulk of the work that we do.
And do you find a situation where the terminations do pan out as being not unfortunate, but as being unfair?
Yes. More often than not, I can say.
There are those who've argued, I am one of them, that our labor laws are skewed to support the employee, meaning the likelihood of an employer winning a case against an employee are really slim.
I think, to be fair, those ones who argue like you are arguing are those ones who are stuck in the pre-2007 legal regime. Before the 2007 legal regime that we have in the employment and labor relations realm,
yes,
was the common law, principles, where, it's like the employer held immense power and authority over an employee. So that the new regime came in with what I call expansive protections and rights, in favor of an employee to countenance this authority and power that, the employer used to have pre that period. And we should not also forget that the new constitution came in with labor rights, which weren't in the pre-2010 constitution. So really, it's a radical shift that has been in this realm of employment and labor relations, which most people don't seem to appreciate. So hence the narrative that you're giving.
So over time, then, essentially, do we see that the need for individuals now to have some kind of justice when it comes to, any kind of, issues that may have gone on during their employment, the court has then provided a place whereby those desires or those needs then can be met, whereas before that there was no one?
I think, if I get you well, before then, we used to operate in a very different realm, more than we are operating now. The current position is that the law and the constitution is more sensitive to both the employer and the employee. Yes. And now giving the court, the authority to really protect the employees who suffered for a long, long, long time before the new laws.
Judge, the strategy of the Chief Justice is social transformation through access to justice.
Yes.
And among the things that you're marking as you in this year's symposium is how this court is expanding access to justice. Now, various other judges that we've hosted on this show have talked about alternative dispute resolution mechanisms, and various high courts and even the magistracy seeking a lot of ADR. Is there a way that people come to your court and you actually send them to alternative dispute resolution?
Yes, and I think that's one of the strategies that we are employing to try to create backlog. It's a constitutional imperative. It's one of those, dispute resolution systems provided for in the Constitution. And because the Constitution gives that, we are duty-bound to refer matters which can be adjudicated in that process to that process.
Like which ones?
matters which you think do not require lots of expertise. You look at a file like this, look at the claim, look at the response, and you form an impression that it's a simple matter that can be dealt with through, mediation.
Is there an example that you can give us, maybe in your time at the court, where matter has been brought before you?
Yes.
You've looked at it, you've looked at the parties, you've looked at what they've submitted, and you've advised them to go through ADR?
Oh, yeah. For instance, where you are handling a matter to do with unfair termination. You look at the facts presented through pleadings. Check on the aspect of procedural fairness. Check on the aspect of substantive justification for, let's say, the termination or dismissal. And you form an impression that indeed procedural fairness was not followed. There was no notification to the employee of the grounds forming the basis for the intention to dismiss. There was no, hearing given to this employee. There was no, consideration of any representations he made, if at all he did. And maybe you find that out of somebody just looked at the employee and said, I don't like your face, and you have to quit.
Yeah.
That cannot be a valid reason. And looking at that, and you're forming an impression that basically here, the dismissal was unfair. You just refer this matter to mediation because it's a faster way of dealing with the issue. Yeah. Instead of, taking evidence and taking 2 months to do a judgment of such a simple matter which you think is clear that there was an unfair dismissal or termination.
So do those make up a bulk of the cases that come to the Employment and Labour Relations Court? Those who are coming seeking some kind of compensation for unfair dismissal or reinstatement, do those make up the larger percentage of the cases that come?
Yeah. As I said, they form like 60% of what we do.
All right.
Yep.
Now, what are we looking at for a lot of these individuals who are coming before the court? Are they looking for reinstatement? Are they looking for some kind of, compensatory hand that's being dealt out? And then how then is it determined that this individual either is compensated or then the office is asked to bring them back? Whereas I realize that if they left under any kind of, acrimonious circumstances, asking that individual to come back into a place of employment then might be jumping from frying pan into fire.
Yeah, litigants come to court for various remedies. And what remedy you accord as a court is heavily dependent on the circumstances of each case. For example, one of the remedies, recognized by law, the Employment Act under Section 49 of that Act, Employment Act, is reinstatement. An award of reinstatement to an employee who has been unfairly terminated is discretionary. You have to consider various factors. For instance, after the dismissal, what period has lapsed up to the time you are making your determination. If it's beyond 3 years, again, there is a limitation. You cannot give that remedy. Again, you have to consider whether it's practicable, for you to tell the employee to get back to work. Is that work environment going to be conducive for him to work? Is that order really in accord with what we normally push for, harmony at the place of work? Yeah, so if you find like before you left the environment was very toxic, then you cannot make an order for reinstatement. Yes. So, yes, it depends on the circumstances of each case.
You talked about a matter maybe being simple enough to go towards mediation. usually, is it something that maybe you need a little bit more time to iron out, or you say, look, this is not necessary for us to bring it here, go towards mediation, then essentially the court is satisfied or would recommend that it goes for mediation instead of staying within the walls of the court. But the question then would be, if they do go for mediation, having been recommended by the court, we know that the outcome of mediation then is the outcomes of mediation are essentially as steadfast as a court ruling, right? If they are not satisfied with mediation, do you ever see circumstances whereby they would say, this cannot work, it has to come back to the court, and this was something that was then referred by the court in the first place?
Yeah, we have seen situations where, you refer matter to mediation, and when the parties get to the mediator, they don't agree. So, in a mediation process, the outcome is supposed to come from the parties themselves. So if they don't agree, then there's no agreement. The best the mediator can do is to do what we call a certificate of no agreement, then return the file back to court so that the court proceeds to adjudicate over the matter.
In such instances, you're a human being.
Yes.
You're the judge who referred this matter to alternative dispute resolution. You told them, go for mediation, because I'm looking at facts that you've presented here, and I think you can resolve this matter. Then the mediator tells you, these people have been unable to resolve this matter, to agree. They come back to you as a human being. Do you now look at me and say, okay, now let me see the one who's the hard head here, I'm going to show them. And unajifanya kichwa ngumu, unakataa kusikiza.
No. Such factors should not bear an influence on how a judge operates. Yes, yours is to render justice, looking at the facts, the evidence, and the documents presented before you. Yeah, those are extraneous matters really, which you should not allow to sink into your head to influence your decision.
But then would you want to dig deeper into finding out what exactly is it that is making these two parties not agree? Now you may want to look at the strictness of the letter of the law, but there's something deeper here, Judge. The reason that these two parties are not agreeing, it goes beyond the letter of the law. It's something more personal. Are you inclined to want to find out what exactly is going on here? Why are you people digging in on a matter that you clearly could be resolving?
Now, in our adversarial system, where you have to make a determination on material presented before you by Mr. X, the claimant, and Madam Y, the respondent, you just confine yourself to the pleadings, to the evidence present before you, and to submissions made by counsel, if any. Then render your decision. Don't go, searching, fishing for
waterfalls.
Those other things that are penned outside there before the mediator. Otherwise, your minds will be crowded.
What I'm basically hearing you saying is that you had given them the opportunity the first time when you sent them for mediation and told them, go resolve your personal disputes. And now if they're unable to, now they come here, they basically better be prepared. You are going to look at the law, you will apply the law. And the one who the law finds has erred here will face the consequences.
Yeah, and they should be ready to face that reality that the matter will take a longer period to be determined than it could have been if they had embraced the mediation.
Okay.
Yeah.
2 weeks ago, we hosted the Honorable Justice Jacob Gakeri, also from the court. And among the things that he told us is, when we talk about case backlog, one of the reasons we have case backlog is delays and adjournments. Adjournments have been a thorn in the flesh of courts, not just your court, but even all the other courts. And causes of delays, 68% of these adjournments are contributed by advocates. Now, you were practicing until recently, until you joined the court, okay? You came from the other side,
Now he's joined the other side.
Now you came from the bar, now you're on the bench.
Yes.
And you obviously then understand the tricks and tactics that advocates would use when they are coming to the court and they are applying for these adjournments. How do you now deal with that?
Without experience, I know that sometimes there are those adjournments which are sought not for very, very good grounds. So my approach has been that first, you ensure that you create that culture of, people appreciating that you don't walk into court and get an adjournment as and when you want it. People must appreciate the advocate's litigants that an application for adjournment is not automatically given. So what we have embraced is a no adjournment policy. Yes, you have to really convince me that you deserve the adjournment.
Take me through the thinking of the advocates, though. Why would an advocate just come and seek an adjournment with no strong reason? How does it benefit them and their client?
Yeah, maybe sometimes he forgot to inform his client about the hearing date. Maybe he is not prepared to handle the case on that day, and he has to seek for adjournment. And remember, an advocate owes a duty to his client to render services paid for. So to come to court and try to adjourn is to shield himself from any potential disciplinary action being taken against him by the Law Society of Kenya through the disciplinary tribunal. Yes.
Do you think the bench should actually take this matter up with the Law Society of Kenya?
No,
so that there is better, because it sounds like there are cases where there could be genuine need for applying for adjournment. And in some cases, it's just because this advocate A is not really committed to their client's case. That's why they would forget to inform the client. They'd maybe take over too much work and then not be able to service all their clients. So they're not prepared for this particular case. They were working on another one that's in another court in the afternoon. So this is all not rendering justice. They become a hindrance to access to justice. Should the bench actually have a sitting with the Law Society of Kenya and say, look, we have all these cases, we have all these applications for adjournment, look at them, do something?
I don't think so, because we are impartial actors. We must not only dispense justice, but be seen to dispense justice. So the moment you decide now to, you want to be the complainant to the Law Society of Kenya, you shall have ceased to be an impartial actor. You are jumping into the field. And you will be accused that now it's like you are becoming an advocate for the other party. Now, people not see it as you are trying to ensure that there's expeditious dispensation of justice. Somebody will feel that you have an hidden agenda to support the case of the other side. You shall have accepted bias, so to speak.
But hear me out, Judge.
Yes.
You're all jurists, all right? Bench, bar. For the benefit of this profession of yours, you are sitting here and you're adjudicating a case, and you will deal with the counterparties there who are advocates. But you can see that there's something that's happening to the profession at that level of the bar. Is it not important to at least have this conversation at some point and raise it and say, we are the ones who appear to be delaying or the bottleneck to justice, but we are actually not the ones who are the bottlenecks to justice?
Oh, that we have done severally. In conferences where we have been invited to speak, in CUC meetings where LSK is represented, Yeah, we keep on telling them, we are not the problem. The problem is these unnecessary adjournments caused by your members. Yes, that we keep on preaching whenever we have a chance to so do.
Aside from adjournments, because we look at them and we tend to think that these are clearly the reasons why some of these cases take too long. And somebody who looks from the outside in would ask themselves, then why do these, apart from adjournments, why do they take so long? If we're looking at an employment case, for example, and I guess that's one of the reasons why you're here, to debunk some of these things.
Sure.
It would be simple in our eyes if I worked for the company of Eric and Siti and Sons, and I feel as though they have dismissed me unfairly because, I don't know, I became pregnant, and as a result of that, I could not dispense my duties according to them. But I felt as though I could still do the job. They got rid of me anyway, in what I feel is a misogynistic manner. I collect my evidence. I don't need representation legally because it's clear, cut and dry, isn't it?
Yes.
And we lodge the case before court. Now, it seems really easy. It seems really simple. I may even have a witness or two in the office. Edna has seen, another person has seen, they have witness testimony. To me, it seems pretty cut and dry. We come before, we mention the case, judge tells us, come back on another day, let's get through this thing. It seems like it could be a day's work, isn't it? But then we find these, and evidence is there, documentation is there. I have not shown that I would not be able to do my work because of the condition, but they've gotten rid of me anyway. We have all the documentation. It seems cut and dry, isn't it? But a case like that can take 2 years to adjudicate over. And so the question for a lot of people out here is, why does it take so long for something that would seem easy and quick?
Okay, there are so many factors, but one of the main factor here is, and which should be appreciated, is that when you file your case today, there are so many other matters on the queue. So that the matter can be so simple, but we are not going to give it a priority date for hearing just because it's a simple matter. Okay. It has to wait on the queue until it's reached. Remember, I said this is a court which has been operating with 9 judges. For example, if I may give an example of our court. 9 judges dealing with 10,000 cases in that court. It's almost impossible.
It's over 1,000 cases per judge.
To talk of like clearing cases with the speed that Kenyans expect. When I joined this court, my first docket of cases was 500. I can't do 10 cases in a day. So you can imagine for how long, if you filed your case today, you are going to wait on the queue until your matter is reached.
Meaning you get to the back of the queue.
Yes.
And yet, if somebody came and filed under a certificate of urgency, somehow some time would be found. Or can we not file for certificates of urgency within the ELRC?
And I think we need to understand what certificate of urgency means.
Please, yes.
Yes, so that people should not have an impression or a perception that, I'll just shout certificate of urgency and my mother is
jump the queue.
Definitely.
Yeah, so what happens is that, there are situations which must be preserved. For instance, if you find like somebody is going to have an unlawful, conduct or action being undertaken, and you feel that there's a serious prejudice that is likely to be suffered, and justifiably, You can come to court, explain that situation, and under that thing you call certificate of urgency, get what we call a preservatory order. Just preserving the status pending the hearing.
It doesn't mean that the hearing will now begin.
No.
Because of, they said, do not fire this person. Hold on.
Until we resolve the dispute. So Lily doesn't read to people jumping the queue and having very young matters, if I may use that term, to be ahead of old matters.
Okay.
Yes.
I want to ask a question just on that. And then you can, in such an instance where Ndu has jumped to court to sue CT and Eric company for CT and Sons for for unfair dismissal, all right?
Yes.
And now they want those preservatory orders. So the court says, all right, until we hear this matter, we are seeing this is about unfair dismissal. Do not fire Ndu yet, okay? Until this matter is heard and determined. So Ndu stays in employment, earning a salary and have full benefits and everything else. And then this matter is concluded 5 years down the road, and you find that City and Sons was actually on the right in seeking to dismiss Ndu 5 years ago. What happens to the money that City has paid to Ndu in that time?
I think when we give conservatory orders, we preserve the situation as at that time. That means she continues running a service.
She was working for the company.
She was working.
City was firing her because she was reporting to work. She was not working. That's why City thought, you are a waste of space. Chai is office. And so she continues in those 5 years with her bad manners in the office. After all, koti liniambia kuna mahali mnanipeleka.
I'm not getting your question clearly.
I'm saying that in the end, you will find that City's grounds for dismissal and the process that he used to dismiss her was actually lawful. His grounds for dismissal was that he felt that she is not adding value to the company and she was misbehaving at work, and she, basically those things that employees do. Such employees. And that's why City and Sons, the company, was seeking to dismiss this employee. All right? Now, you preserved the status as it was. So she continued being in employment of City and Sons company. But she continued with her bad manners. So she wasn't really delivering value to the company. That on the side, City still had to employ somebody, a junior person, to carry the load that this office should have been holding. And her, because of the impunity of knowing that I have the court on my side, she actually even got worse. She was now reporting to work at 8:30, leaving at 2:30, and saying, utanipeleka wapi?
No, I get you. I think that's a misconception.
Okay.
This injunction or conservatory order that one gets is not a license for him or her to continue perpetuating acts which might look a misconduct. And if that happens, if after getting the conservatory order or a restraint order, she decides now to say, okay, here I have a shield. What are you going to do? You can't do anything against me. That employer has a right to come to court and say, lift this conservatory order because of reason A, B, C, D. Since you gave this order, this employer has become big-headed. This is what she has continued to do. And the court, if convinced, can lift or discharge that order. So it's not a complete shield. It's not a license for an employee to go out there and now continue misbehaving. and getting big-headed, so to speak, if I may use that term.
You know, Justice, there was a time gone by in the previous century when one heard of labor officers, and when there were disputes in a work setting, an industrial setting. I say this because I came across them myself at some point in my life. They seem to be the ones who are charged with the duty of sorting out these disputes. Now, in this present day and age, and with the 2010 Constitution, what is the role of labor officers and what do they do? And are they still relevant?
In fact, they play a very big role. Those are the conciliators of today, providing an alternative avenue of dispute resolution. You'll be shocked. Yesterday, we had data from the Ministry of Labor and Social Protection, and we were informed that in the past 1 year, around 8,000 cases have been resolved through conciliation, through the labor officers, because those are the conciliators. Yeah, so a huge chunk of cases was impeded from getting to court. And that's why we are saying that as much as possible, we should promote mediation, reconciliation, and negotiations as a form of dispute resolution.
You know, I hear you and I understand what you're saying, but again, my lived experience with the said officers was what I experienced and what I heard from others was part of the reason that people ended up going to court was because it was then said, not all, but a good number of labor officers were susceptible to being influenced, meaning their position in this mediation was biased. And the employer tended to have the upper hand because the employer had more means than the employee. So when the employee was aggrieved and felt that the matter that was discussed and adjudicated by the labor officers was inadequate according to them, they then went to court.
I don't agree with you. I think that perception could have been a misplaced perception. The perception that they were favoring employers,
Yes.
Against employees was not well thought, because I think then, if you are talking of pre-2007, the structure of the law was inclined to favor the employer. You know, I remember I said we were using the common law principles.
Yes.
Where the employer wielded lots of authority. He could fire at will. And there's nothing, you know, the labor officer could do other than applying that principle. You have been given notice, terminated without cause, because then the employer could terminate at will. Unlike today, when you must have cause to terminate, and a valid cause. So really, it's not that the labor officers were corrupt in a way, so to speak. It's because of the realm, the legal regime under which they were operating, which was not very protective to the employee. And the perception now being influenced because of lack of understanding of the environment within which those labor officers were acting.
Okay.
Yes.
So what we're saying is basically the law has reformed this space, and the employee is now more protected by law. The employer is also, I'm expecting, more protected by law. Is it?
I think it's a balance. As I said, the new legal dispensation in this sector was to somehow countenance, to try and balance the power that the employer had over the employee. Immense power he had.
Yeah.
So that the employee was the weakest person in the bargain. But nowadays, it's a little bit balanced. You cannot, hire and fire at will.
Yeah.
You have to fire with cause.
Very.
You have to follow procedure. That never used to happen. All that used to happen is, I have paid you, I've given pay
I've
in
paid
lieu
you
of
in lieu of
notice.
Go.
And that was it. Go.
Aye.
And that would be 3 months salary, 1 month salary. You have worked for 50 years and you...
Or you're on probation, so no notice needed.
Just
get out
been
and go.
sacked like that, yeah.
Judge, thank you very much for joining us today.
Thank you so much.
This is the Situation Room, the only way to start your day.